morning, everybody. So we're going to wait for a bunch of people to get in. If you can smash that like on your way in, that would be great. We'll get this out in the algorithm so we can get going. So let me just get these in order here so I can show you all. We have a lot of, good morning, Nana. We've got a lot of new stuff to go over, some information that just came out this morning, you guys. I was going to wait till this afternoon to do this because I'm not really feeling that great, but there's new information that just was released this morning. So, well, it was just put to the record this morning. It was released late yesterday regarding Lori Vallow. Good morning, Sammy, Buffalo Mountain, Sylvia. Good morning, everybody. Please smash that like on your way in. There's my sister. Good morning, sister. Please smash the like on your way in so everybody knows that we're live so we can get going on this and also show some support for the channel. And it's free. Also, when you come back in after smashing that like, make sure you have live chat selected at the top of your screen so you don't miss anything. Okay, so I'm just going to thank you, you guys. I see that like button going up. Thank you, thank you. Gets us out there in the algorithm. Thank you. I'm just going to get these in order so I can show you what happened first. Like this truly, 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 you guys, is a circus. Real Angel, good morning. Sammy Smith, good morning. And W Love, good morning. I love the hearts and the, let me just put that up. I just seen that. That's the first time I ever see the white hearts and the doves. Beautiful. Thank you so, so much. Thank you, Sammy. Okay. So Lori, I think, is playing her games again. We'll get to that at the end. The email that I received. Okay, so let me just show this first so we can go over this. Yes, they're beautiful birds. Beautiful, beautiful birds. Okay. I'm just having my first morning coffee, you guys, too. And just went to the doctor's yesterday, found out I got a major bladder infection. And oh my gosh. So it's pretty painful, but we're going to get through this, you guys. With you guys, we're going to get through this. I ain't dying, so that's good. Okay. Let me just... There's a bunch of stuff from a bunch of different places here. Okay. And it's, oh, thank you. It's all right. It's not as bad as I thought things were going to be because I have a lot of problems in my guts. So it's, at least they got me on this antibiotic and a painkiller that knocks me right out. So it's like I was groggy as shit this morning when I woke up and I seen this email that I got regarding Lori, and it's like, oh my God. So after everything I just read and everything else and what I want to show you guys what's going on in this court case, there's a very real possibility that Lori's going to walk, but we'll get to that. I'll explain it all if you guys don't understand. I've got a lot of comments since I put out the post yesterday saying that her lawyers have motioned the court for a dismissal. People said, no, they'll just file the charges again. That's not how it works. The only way that works like that is if it's dismissed without prejudice. And this would be a case where it would be dismissed with prejudice. So that means that there was some wrongdoing towards her, which means double jeopardy comes into effect. They could not charge her again. They could not file these charges again for the same charges. They couldn't do it. So I want to make that clear with you guys. Well, thank you, NW Love. I'm not one to take painkillers and stuff like that, but the pain was so bad and it knocked me right out. I think at 4 o'clock yesterday afternoon, I was out cold. I came home, took the medication, didn't read it, and it was like I was about to start cooking something to eat, and it's like, okay, I'm just going to go and lay down on the couch for a minute because I was feeling dizzy. And I was out cold. I didn't wake up until I don't even know what time it was. It was like a god-awful time. But it works. Yes, it is just a mess. Okay, so let's go back to this one. This one was filed on the 18th. We're going to go from everything that just hit the record. This was filed on the 18th. Subpoena Ducis Tecum. Okay? So this was filed by James Archibald. You can see up here. And you know me, you guys, going over paperwork. I'm very picky, and it's got to be done properly. And there's some things that I've seen in here in further filings that I'll show you. I've got 1, 2, 3, 4, 5, 6 that I want to show you, plus the email I got this morning. Yes, I called this from the beginning when this started. It's like, no. She's going to walk, you guys. She's going to walk. Okay, so whoops. So they filed this on the 18th, I believe it was. Let me see. The 19th. Okay. So they want, this is a subpoena for Dave Channer from the Church of Jesus Christ of Latter-day Saints. And it says, you are hereby commanded to appear before Judge Stephen Boyce of the District Court of the 7th Judicial District, County of Fremont, State of Idaho, at St. Anthony's at the courthouse in the said county on February 2nd. So I got to write that down. February 2nd. As a witness in the above captioned proceeding. Any and all church records, including attendance records, temple records, disciplinary records, records of accomplishment, or any other records in your possession or control that may pertain to Lori Noreen Vallow, a.k.a. Lori Noreen Daybell, a.k.a. Lori Noreen Cox, a.k.a. Lori Noreen Ryan, with a date of birth of June 26, 1973. Attendance at the hearing can be prevented by providing the required documents to the law office of James Archibald within 7 business days of this notice of the service of this subpoena to, and he gives his email, or by mailing. He gives the address. You're further notified that if you fail to appear or have this information made available prior to or at the place and time specified above, that you may be held in contempt of court, and that the aggrieved party may recover from you the sum of $100. Because she needs some new lipstick. And all damages which the party may sustain by your failure to provide these documents. So in my opinion, you guys, why they want all this here, this is what I'm concerned about here. What they want is they're going to try and show that she was an upstanding person that went to this church, how all the good things she did, and that's what they're trying to gather. They're trying to boast her here, and that's why they want these records. It's also going to show when she actually joined the church, before Chad Daybell, all that kind of stuff, when things really changed. It's going to show a lot. Okay, so that's why they've subpoenaed this information and subpoenaed him. Now, he doesn't have to give this because by law, he doesn't have to turn anything over until he's ordered to do so by the judge. So I would assume that he is going to show up at court, and he's going to wait for the judge to order that. Like just some lawyer sending him a letter saying, give us all the information on Lori, doesn't generally cut it, especially with the church and doctors and stuff like that, unless it's ordered by the court. I I don't think he's going to send it in. I think he's going to show up in court. Okay, so we'll go to the next one. Okay, so my last coverage of this is when Lori and Chad were in court. This is one of the orders. If you remember when it first started, it was last week, when they were going through the motions hearing last week, the judge was making decisions right away, nothing under advisement, right away. And I spoke too soon in that while we were going over that hearing, because all of a sudden then he started taking things under advisement. But there are a couple orders that he made. And this was regarding the state's motion to sequester the jury. As you can see here, on September 29, 2021, the plaintiff, the state of Iowa, filed a motion to sequester jury and requested this court to enter an order sequestering the jury during the entire pendency of trial scheduled in this case. On January 11th, the defendant, Chad Guy Daybell, filed an objection to the state's motion. The court heard the parties in argument on the motion on January 19th, 2023. For the reasons stated upon the record at the hearing, the state's motion is denied. Now, remember the court date. They were in court last on January 19th. Okay? And that's just the certificate of service. So, January 20th. This one was filed, and this is an order, the second order that Lori's lawyer had filed to get a motion for joint settlement strategy sessions. January 5th, Lori Noreen, and these dates, you guys, because this was all done on the 19th. This is all very important, okay? So on January 5th, 2023, the defendant, Lori Noreen Vallow Daybell, filed a motion for joint settlement strategy sessions, requesting the court to enter an order permitting defendant Vallow Daybell, an alleged co-conspirator and co-defendant Chad Guy Daybell, Fremont County case number CR 22211623, to meet together with their attorneys present in ongoing meetings. So she didn't want just one; she wanted several, because this is in ongoing meetings. On January 12th, the state of Idaho filed a response raising several concerns surrounding their request. On January 19th, again, the court called the motion for hearing and heard the parties in argument on the motion. For the reasons stated on the record during the hearing, the motion is denied. So that was denied. So sequestering the jury's been denied, and this settlement strategy sessions were denied. So then James Archibald files this motion to dismiss for lack of speedy trial. Now, also in that hearing, okay, John Pryor argued a motion to continue the trial for a year. Okay, so he didn't want it done until 2024, like late 2024. He's saying that he doesn't have enough information, and with these new hair fibers coming into play and things that he still doesn't have, that he hasn't been able to get the case together and be ready for trial, when in fact, when we went over that, if you haven't seen that video, I'll link it at the end. You'll see a card pop up on the screen. I'll put it there. John Pryor is actually the one that pushed to have the January 9th trial date. Now, I believe that he was playing games. He was thinking, Lori hasn't waived her right to speedy trial. This is his way of getting the case severed without having to fight and argue about it. So he's going to figure, no, I want the trial to start in January, knowing that because Lori had not waived her right to a speedy trial, they would have had to have her trial in October. It's within 6 months after her arraignment. Okay. She was arraigned, I think, in April. So they had to have her, because she didn't waive her right to a speedy trial like everybody thinks she did. There's a lot of people commenting she waived her right. No, she didn't. This is one thing she has been fighting. So her trial was originally set for October of 2022. Now, with John Pryor getting this January 9th, 2023 date as the date that he insisted up and down, I'm going to be ready, blah, 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 blah. Even though the court, the prosecution raised concerns saying, I think we should put it off until the fall of 2023. John Pryor fought that. He said, no, I will be ready to go in January. So what that did was it put in motion the speedy trial with Lori Vallow and her right to a speedy trial that she has not waived and has been adamant about wanting her speedy trial. So that was brought back in front of the judge, and the judge turned around and said, well, we know you have a right to a speedy trial and we have this date for October, but these cases are so much that we're going to be using the same information, all this stuff. So we are going to, we feel, the prosecution and the court felt that they were within their rights to go outside of her right to a speedy trial because it was only a couple months down the line. So it was only a couple extra months. And her defense team was like, well, give us a little bit more time. So they kind of sloughed it off. Well, then Lori ends up back in the mental hospital, but she's back in time to start this trial. But in the meantime, John Pryor has turned around now and said, well, you know what, Your Honor, he made another motion to continue. I'm not going to be ready now for January 9th. Okay? He says, we're going to have to push this out to April. Or he wanted it in October. And what the judge said was, oh, no, we're not pushing it till October. We have Lori Vallow's speedy trial rights to consider, and this is a joint trial, so we're going to put it to April. So the court date was again changed from the 9th for Lori, from October to the 9th of January, from the 9th of January now till April. So now it's been put out even longer. Another 6 months. So that is a year from the time that she's been arraigned. That's a no-no. The judge should have seen this coming. I called it back when her trial was set to begin in October and they pushed it out to January on her against her speedy trial rights. I called it back then that there was going to be a big problem, that this is going to set her up to have her charges thrown out. But everybody said I didn't know what I was talking about. So here we go. So now that the January trial didn't happen, now it's pushed out to April. And now John Pryor was in court on the 19th and now wants it pushed out to 2024. And the reason he can do this, you guys, is because he's saying he's not ready. And because the speedy trial has been waived, he can keep pushing it out and pushing it out and pushing it out. If he says that they're not ready or they don't have all the evidence, they're citing now Brady violations and everything else, that they need all this information before they can put this defense together in full. Well, what he's actually doing is he said back at the last time when they set the court date for January 9th that he was ready to go. So now he's backtracking. So now he wants it put off until October of 2024. So sitting there and being Jim Archibald, I'm thinking, what? Even the April date, that's a year almost to the day of when she was arraigned. She didn't waive her right to a speedy trial, so they should have had her in trial 6 months prior. So now it's been a year. Her rights have, and you guys are going to jump all over me, clearly been violated. Now, a lot of people are saying, well, no, they haven't, because she's the one that, claimed insanity and this and that, and was in the mental hospital in and out for a year and a half after she was arrested. But what I'm saying is the right to a speedy trial does not come into effect until you are arraigned. She was only arraigned on her charges last April. So from the time that you are arraigned, there's the last time she was in the hospital It did not interfere with the dates that were set for trial. She was back in time to go ahead with the trial had John Pryor not got a continuance on it. Okay? So, although the first year and a half that she was in custody and charged, yes, she was in a mental institution, having evaluations done, whatever. But the speedy trial rule does not come into effect until they are arraigned. So she was arraigned last April. She had a right to a speedy trial within 6 months, which would have brought us to October. They set an October trial date. That would have all went through. They were going through with it, the defense, Lori's defense team and Lori. It's because of John Pryor that court date was vacated and it was set to January, where John Pryor demanded that date and said that he was ready to go in January, but he was not ready to go in October. So he was not going to agree to have Chad's case moved to October so they could do it together with Lori's. So what they did is they moved the Lori's trial date up to meet Chad's in January. And this was both supposed to go as a joint case together in January until again, John Pryor had it vacated and moved to April. So now as Jim Archibald, Lori's lawyer, he has and I know you're going to jump all over me for this, but the law is the law. What he's doing by filing this motion to dismiss, I agree with it. She is evil. She is, and I believe she'll murder again if she gets out. It's not her playing games this time, the real angel. This is John Pryor. John Pryor wants this trial separated. He's wanted it separated for 2 years now. And this is the route that he's been going to get that separation. Okay? In the meantime, while he's playing games with the court did a big boo-boo with not severing these cases and having her case go in October. She had that right. No matter what a person has done, they still have rights under the Constitution. The insanity, whatever she did that first year and a half doesn't matter. It's what happened since her arraignment. She has gone back. I believe the last time was there was medication that had to be altered. So she has to be watched during that time of alteration of this medication. So that's not her fault. If she's freaking out and stuff, yeah, it would have had to be her medication had to have been upped or something. Right now, who's playing games is John Pryor because he wants this trial separated. And this is how he's doing it, okay? Which sets up Lori Vallow and her team to do exactly what we're looking at on screen now. So let's go over it. In the District Court of the 7th Judicial District in the state of Idaho in for Fremont County, motion to dismiss for lack of speedy trial. Comes now the defendant, Lori Vallow, through her attorneys and pursuant to the Constitution of the United States, Amendment 6, the Constitution of the State of Idaho, Article 1, Section 13, and Idaho 19-3501, moves the court to dismiss this case as the government has violated her right to a speedy trial. Now, in asking for this, and the way he has written it, moves the court to dismiss the case as the government has violated her right to a speedy trial. If this motion to dismiss goes through, it's going to be with prejudice, which means they can never file these charges against her again. Now, without prejudice would be different, which means once they gather more information, they could refile, like we've seen in the Barry Morphew case. That was without prejudice, which means the state could refile at any time. This is going to be with prejudice because Jim Archibald is saying this is a government error, a government move that violated her right to a speedy trial, and I agree. I don't want to have to agree, but I have to agree here. The judge should have seen that. I seen it coming. I told you guys, hey, all you guys that have been following me all this time, going through these documents, I said it how long ago? I said it back when they wanted to change her October date. I said this is going to happen. Oh, no, it won't. And then I'm getting people in my comments saying, oh, well, they'll just file the charges again and have to start all over. No, that's not how it works. If they prove that the government violated her right to a speedy trial, the case is dismissed with prejudice. And what that means is they can never charge her again on these charges. Right? I think this is a setup between the two of them. I think the two legal teams got together and set this all up, if you want my honest opinion. And Lord help if that can ever be proved. But the way John Pryor is going to get about this, he's saying, oh, well, we can't be ready now because now there's new information. He also cited in a motion that, well, we haven't got all the disclosure. We haven't got this, we haven't got that. And the prosecution's saying, look it, we've said that 3 times now because 3 times you've said you didn't have it and we've sent it. Right? Yeah, she would still be held on. She would be extradited to Arizona. If she beats these charges, she would still be extradited. She wouldn't be getting out, but she would get extradited to Arizona to face the charges in the death of Charles Vallow. Yeah, and that's what I was saying. I think they're playing a game. Okay, so let's continue reading this, you guys. Motion to dismiss for lack of it. The accused shall enjoy the right to a speedy trial. The Constitution of the United States, Amendment 6. The accused shall have a right to a speedy trial. Constitution of the State of Idaho, Article 1, Section 13. Since the term speedy trial does not specify the length of time required to bring an accused to trial, federal law enacted a timeline for someone charged with a federal crime, and each state in the union enacted laws to define what it means in their respective states. The Idaho legislature defines speedy trial in Idaho Code 193501 as follows. The court, unless good cause to the contrary is shown, must order the prosecution or indictment to be dismissed in the following cases. If a defendant whose trial has not been postponed upon their own application, which means Lori, so if Lori filed to have her trial postponed, they could not try and get this dismissed, but they didn't do that. Is not brought to trial. Okay, so if a defendant whose trial has not been postponed upon his application is not brought to trial within 6 months from the date that the defendant was arraigned before the court in which the indictment is found. That is the speedy trial. They have 6 months to get her to trial from the date of arraignment. In the State versus Clark, 135 Idaho 255 in 2000, the Idaho Supreme Court took up the speedy trial issue and the determination of good cause. Upon careful consideration of the relevant authorities, we believe that a thorough analysis of the reasons for the delay represent the soundest method for determining which constitutes good cause. We therefore conclude that good cause means that there is a substantial reason that arises to the level of a legal excuse for the delay. Because there is not a fixed rule for determining good cause for the delay of a trial, the matter is initially left to the discretion of the trial court. That's how he used, Judge Boyce used that right there to put her trial from to take away her speedy right trial from October and bring it to January. Okay? But to me, there wasn't good enough cause to push it out until April, and that's where we're having the problem. The good cause determination may take into account the factors listed in Barker versus Wingo. The Barker factors, however, considered only as surrounding circumstances are important, if at all, only insofar as they bear on the sufficiency of the reason itself. The shortness of the period, the failure of the defendant to demand a speedy trial, and the absence of prejudice are legitimate consideration only insofar as they affect the strength of the reason for the delay. Now, she has, each time they've been in front of that judge, they have said, Lori Vallow wants her speedy trial. They've made sure that was on record. So, where was I now? This means that to whatever extent the delay has been a short one, or the defendant has not demanded a speedy trial or is not prejudiced, a weaker reason will constitute good cause. Now, the only way that they can use that is if the defendant has not demanded a speedy trial. She has. Each and every time they've gone to court, she's demanded her speedy trial. So they cannot use the weaker reason. So a weaker reason cannot be used to prolong this. But it says here, if the defendant has not demanded her speedy trial, a weaker reason will constitute good cause. On the other hand, if the delay has been a long one, or if the defendant has demanded a speedy trial or is prejudiced, a stronger reason is necessary to constitute good cause. Now, good cause has to be something legally with the case. Okay? It's a very specific rule. Now, them saying, wow, it's going to cost us too much to have two separate trials and it's going to be the same information. That's not going to be good enough. Okay? Right now, the only reason why the prosecution and courts keep allowing Pryor to do what he's doing, and I really, honestly, you guys, I don't think Pryor can believe that he's getting all these continuances because he's doing it to try and get this trial separated. And I think he's mind blown that the judge keeps doing it, knowing that this is going to affect the Lori speedy trial. Thus, the ultimate question of whether legal excuse has been shown is a matter for judicial determination upon the facts and circumstances of each case. A trial judge does not have unbridled discretion to find good cause. However, and on appeal, we will independently review the lower court's decision. Right? So if he decides to go against this motion now and say, oh no, you're going to court in April, this could be a reason for her for appeal. Okay, so they're going to give this. And this explains everything, okay? The following is a timeline in the cases against Lori Vallow Daybell. February 20th, arrested in Hawaii, $5 million bond, and she had two cases here. Madison was regarding the kids. Well, they're all regarding the kids, but one is the disappearance of the kids and not producing them, and the other is when they found the children deceased. So on May 25th, an indictment from the grand jury in Fremont County, two previous cases dismissed, no bond. So this is when the grand jury indicted her for the murders. April 19th, arraignment on indictment. So you see, from May 25th, 2021 until April, almost a year, she was in the facility being evaluated. She had not been arraigned yet. There was an indictment from the grand jury, but she had not been arraigned yet on that indictment. The arraignment only happened in April. Okay? So, this does not count in her right for a speedy trial because the right to a speedy trial only starts after arraignment, which is April 19th. So, they set, which falls within her speedy trial, October 11th, she was supposed to go to trial. That was the first trial setting on the indictment. The government then requested more time. The government. So then they set it to January 9th. Second trial setting on indictment. Then that was vacated because of John Pryor. And this, John Pryor said he didn't get this stuff from the government. The government was saying, well, we need more time to get it to him, blah, 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 blah. So it was put off till January 9th and then put off again until April 3rd. That's the third date. Now, look at the date that she was arraigned. April 19th, almost a year later, she's maybe going to trial. And now John Pryor wants to vacate this date too. Okay. I think he put this in here as a shock factor. I think the judge should see right through this because she was only arraigned, even though she was arrested here, indicted here. The judge knows, because I think he's the only one that's ever sat in this case. He knows that she was gone for a mental health evaluation. So I think him putting this 1,169 days in jail, although it's true, I think he's putting it there for a shock value. The first setting in this case, in this instant case, was for October 11th, 2022. Since that was within 6 months of April 9th, 2022. So there's her speedy trial. Okay, they set a date for October 11th. The government then asked for more time, and the court granted the request and set the trial for January 9th, 2023. Now, the government asked for this because Chad's was set for January 9th. So now they want to move hers from October 11th to the January 9th date. The court granted that. And this is true. This violated her right to her speedy trial. So that's one. Now, could that one have been sloughed off? And it's like, okay, look at, she just came back. We've only had 6 months to get all this together. She was charged with the death penalty. They've had the death penalty. This, we need a little bit more time. Her lawyers even said, look at, personally as a lawyer, I'm not opposed, but my client wants her speedy trial. Jim Archibald has said, I would love the extra time to get ready for January 9th, but my client doesn't want that. She wants her speedy trial. That's exactly what happened at that hearing. So the judge took that as, well, Lori's a little cuckoo. So, her lawyer really would like this extra time, but he's saying no to agreeing to this January 9th date because that's what Lori wants him to do, because she wants her speedy trial, which is smart. So the judge ruled on it and said, okay, no, we're going to move hers. It's going to benefit the defense some too. There's enough here that, it's only a couple months. It's not really a huge violation. But now they're moving it again. So I can see why he's doing this. And now John Pryor wants it moved again from April to 2024, which I think Jim Archibald at this point is throwing up his hands going, look, I'm done with this. I want a dismissal. I'm tired of having to fight to get our client in front of the court and have her trial as she is entitled to. She was entitled to a speedy trial. We let it go with the January 9th date. Then it was changed to April. We're not happy about that. And now he wants to change it again. We're definitely not going to put up with that. That's what this is about, you guys. Okay. Jim Archibald said he would be ready to go. He didn't fight for wanting more time. He just said that whatever the judge decides, he'd be okay with if the judge did decide to can her, to vacate her October 11th, because he gave him a little bit more time. He said, but I listened to that court hearing, and he said, but no, we are still saying she wants her speedy trial, and that is set for October. She still wants that date. The judge turned around and vacated the date and set it for January 9th. But so now Jim Archibald's got to go back to his client and say, look, stop it. We got a couple extra months. It's really not that far off. She's probably kicking and screaming saying, I just want this over and done with. I'm tired of dealing with it. So now when they come back for the January 9th, and that one's been vacated, and now it's not till April, I can see Lori flipping out. What happened to my rights to a speedy trial? I can see Jim Archibald saying, well, you're right. But here again, the judge vacated the January 9th, set it to April, and now here comes John Pryor again wanting to set off the April date. So yes, I understand why Jim Archibald filed this. If I would have been her lawyer, I would have done the same thing. Enough's enough. You know what I mean? It's now, the April date is a year out. She has a right to a speedy trial within 6 months of being arraigned. This would be almost a month to the day of her arraignment, a year to the day of her arraignment. That's unacceptable. A month or so off, I can see. But this garbage that's going on, vacating January 9th, setting it for April, now John Pryor wants to vacate the April date and set it to 2024. So this is crazy, you guys. And we'll get through these other up here. This is enough to make her go insane again. You know what I mean? Like, you see, I can't imagine being in her position, nor would I ever want to be, and nor would I be, because I wouldn't harm anybody, unless it's self-defense and my fear for my life. But somebody with a mental health issue, setting aside what she did, okay? If she clearly has a mental health issue of some kind, whether it be anxiety. I don't think she's like cuckoo that she didn't know what she was doing, but I can see her having some kind of anxiety and stress, maybe some PTSD of some kind for something. I get it. I get it. My son suffers from anxiety. And when he goes into an anxiety attack, he pretty much thinks he's dying. Like it almost feels like a heart attack, he says. So I get it. She's done. She just wants to, she's tired of being sick and having all this anxiety and everything. She just wants her speedy trial. I want to get this over and done with. So this isn't the monkey on her back all the time. Does she deserve all this? Yes, she does, you guys. That's not what I'm arguing, and I'm not arguing for her. I'm arguing for the law. The law states they have to have a speedy trial within 6 months. The first one, I was like, oh gosh, I see this being a problem, but it's only a couple months. They'll let it go. But then they vacate that one and set it a few more months down the line. And now this one wants to be set off for another year. No, sorry, but no. So I can see this causing a lot of mental health issues for her, with everything keeping on being changed, especially like anybody who has ever had to deal with anybody with anxiety or ADHD, any kind of issue like that, change and not knowing what's happening when can send you on a downward spiral. And that's why I think she ended up back in the hospital back in December. Thank God they had her back up to par to be able to go through with the January 9th date. She was prepared for that. And then it was vacated. You know what I mean? So now they got it to April. So between January and April now, she's freaking out, right? Which could send her on a downward spiral. And then the last court hearing last week, where John Pryor's saying now he wants to put it out until next year. Like, I can just see how somebody with anxiety, depression, any kind of, mental health issue like that, where this could make them spiral. And this is why when you have a defendant, especially somebody like Lori, who has spent almost a year being brought up to par, get things done with her and get it done quick before she spirals again, right? So I think knowing that John Pryor was going to set this date out from January to April, I think it put her on a downward spiral. Thank God, like I said, they had her brought back up to par for this January 9th hearing for the trial to start. But what happens? There's a motion filed. John Pryor wants it continued again, which means they got to go back into the court, and now it's set for April. She goes in again to court because John Pryor yet again wants it set out now to 2024. That's where we are. Okay, so this did violate her right to a speedy trial, the January 9th date. But I feel like at that point, it's only a couple months. Don't sweat it. It gives us some more time to get more evidence. Like, I can just imagine what he had to say to Lori to calm her down. Sorry, you guys, I'm drinking my coffee as I'm doing this, okay? But I think he could somewhat get her under control for that, to let her know, look, this gives us a little bit more time to get more witnesses for you and everything else. So a couple months isn't that bad. But I think what happened after this has spiraled her. Lori Vallow Daybell's defense team questioned her competence to stand trial, and the court told the case from October 6th to November 15th. A 40-day delay caused by the competency review still doesn't justify. See what I mean here? When she found out that her October 11th court date was vacated and she was going to have to go January 9th, she spiraled. And this is basically what it's saying right here. And like I said, people with anxieties and depressions and stuff like that, that's what's going to happen. They have to know what's happening on each day ahead of time and be prepared for it. Okay. So when she finds out now that that her trial is not going to happen in October, it's going to go to January, she spirals. See this? But she's brought back November 15th. Okay. So she had to get help again, an evaluation or mental help again for 40 days. But that didn't cause the January 9th date not to be able to go through. She was still back for that, okay? Even though that date's violating her right. But this sent her into a tailspin, okay? So a 40-day delay caused by the competency review still doesn't justify a trial setting 3 years after her arrest and almost 1 year after her arraignment. Well, 3 years after her arrest, I have to disagree with him here because there's a year and a bit of that she was in the mental hospital. So stop it. But like I said, I think this is just a shock value. She's been in there for 3 years. Okay, but she really wasn't in the jail for 3 years. She was in the hospital too. But this, yes, 1 year after her arraignment. She's supposed to have a speedy trial if she demands it within 6 months. It's been almost a year because now this has been changed to April, which would bring it a year since arraignment. The government still has an obligation to bring her to a speedy trial, which complies with the constitutions and the Idaho Code. This is 100% true. None of these court dates where Pryor kept putting it off. Has she ever agreed to that? It was made against their right to a speedy trial. And each time that they went into court, Jim Archibald made sure that he said, my client wants her right to a speedy trial. Okay? She's never given up her right, whereas Chad did. 9, from her arrest on February 20th, 2020, until the current trial setting on April 3rd, 2023, is 1,169 days. Well, you got to take out of there where she was in the hospital, because that was partially her doing. So that year, 365 days, plus the other time she's had to go in, say over a year and a half, maybe a year and 4 months, is on her. Without a trial in any of these 3 cases. Well, the 2 have been dropped. So I don't know why he is saying in any of the 3 cases, because the first 2 have been dropped. Her arraignment in this case on April 19th, 2022, until the current trial setting on April 3rd is 349 days, obviously more than the statutory 6-month time limit. Her constitutional rights, including her right to be presumed innocent and her right to a speedy trial, have been ignored by the government. And I gotta admit, you guys, this is true. I hope she fries. I hope. But at this point, this is going to be a huge reason for appeal if the judge does not dismiss her charges. If the judge dismisses her charges, this all goes away. They cannot retry her again. If they find the government violated her constitutional rights to a speedy trial, the charges are dismissed with prejudice, which means that her defense showed the court that there was good reason for it to be dismissed with prejudice. And that means that they have showed that the government is to blame for her not getting her speedy trial right. And that they did something wrong, which I believe they have. The judge should have let her trial go in October. It is undisputed that Lori Daybell has demanded her speedy trial and has never waived her constitutional rights. She is prejudiced every day since she's in jail and unable to post bond. The court has repeatedly reminded the government that it will respect her constitutional right to a speedy trial. The government cannot show good cause to bring Lori Vallow Daybell to trial over 3 years from her arrest and almost 1 year from her arraignment. This court should find that the government has not met its burden to uphold her constitutional rights. Now, this is what I'm going to say. That prosecutor was more concerned about having to spend double the money than to keep this case in a position where they could prosecute. They were more worried about the money going to be spent keeping these two trials together. That's what they were more concerned about that than Lori possibly walking. Okay? When you put money over rights, you're going to lose every time. And I believe that this should be dismissed with prejudice. As much as I hate to say it because I want to see her fry for what she did, the government, prosecution, district attorney, whatever you want to call them, has handed this to her on a silver plate. Has handed it to her. It's not because of evidence or, sorry, you guys, it's not because evidence and we found more evidence, so now we got to put this off. And look at now, we had this. It was all circumstantial, putting her there and putting her as a conspirator. But now we have the actual evidence, and we need to get that tested. It's not that. It's the reasons Lori Vallow is not getting her right to a speedy trial is because we don't want to spend the money of having two trials and having to present the evidence twice. That's why. The only reason that they did not let her trial go back in October is because they wanted these trials joined against both defendants' wishes. Now, when you take away somebody's right, not once, not twice, but 3 times to a speedy trial just to save your office from paying, and it's an enormous amount, you guys, for paying all these extra to have 2 trials and to have to present evidence twice for 2 trials, when you put your needs at the government level above the rights of a defendant, you're handing them a dismissal. So I don't know what's going to happen with this, but wait, we got 2 more. It gets better, you guys. Oh, JDR, thank you. Thank you so much for your super sticker. I appreciate it. It helps out the channel a lot. So before this is even heard, now this is going to be heard. We're going to see the next following documents. The one at the end is the big one, because I think Lori's gone again. After all this, I think she's gone again. And her defense, I think, I'll show you it. Wait till we get to it. I know what her defense is doing here. But anyway, the documents are short. They're only a couple pages, so it's not going to be like we're here for an hour going through a 20-page document, you guys. The Real Angel says, Lori knew exactly what she was doing to act and saying to be evaluated. I don't know if you could fake that for a year, The Real Angel. I have more confidence in the professionals than that. I do think that she has some kind of mental disorder. Do I feel like that mental disorder was enough that she didn't know right from wrong? No. But I do think she has a mental problem. No sane person would do this, right? What the evaluation was for was to what extent did she know right from wrong? That's what they had to get to. But no, I do believe there is something wrong with her canoodle upstairs. The noodles aren't floating around right up there. There's something wrong. It could be something as simple as anxiety. Okay? If she's suffering from depression and anxiety, you cannot understand what's going on in front of you if you are stressed to the max and you're in a panic attack, whatever it is, stuff like that. can make you incompetent to understand what's going on for your trial and to work with your lawyers on the right path. Okay? I don't want to get into it all because it's a lot of technical stuff. Do I believe that that she knew exactly what she was doing? Yes. But when it comes for the arrest and the trial, when she got arrested, did that spark her anxiety and depression and maybe some PTSD from whatever happened maybe in her child? We don't know. We don't have access to those records, right? I'm assuming that there's some kind of either PTSD, anxiety, or depression that keeps landing her back in the hospital. Because if you look at the record, it looks like each time something is set and she knows, okay, you know what? October 11th, I got to calm myself. I got to get ready for this. She gets ready for it. She puts herself through whatever mental stuff she's got to put herself through to get ready for that. And then bang, the rug's pulled out from underneath you. And you know what? Now we're waiting to January. We don't know what's going through her mind. Oh my God, what did they find? What did they get? And put her into a spiral again. You know what I mean? We can't. I know I'm going to get flack for this, you guys, but think of this as, say you're a family member of yours. Take away what she did. Okay, your family member has a problem with depression, anxiety, and PTSD. You know that in the morning, you get up, things have to be the same every day. Your son, daughter, mother, father, whoever it is used to, I get up in the morning, they feed me my breakfast, I get dressed, I get on the bus, I go to school. I'm in school, I come home, I get off the bus, and they're there waiting for me, and I have my dinner. You deviate from that with people with some mental health issues, that puts them into a spiral, okay? They could put them into a panic attack. It could, a whole bunch of things. I'm not a health professional, but I know from experience with my son having anxiety and panic attacks, this could have sent her in a downward spiral. Now, am I saying that that's an excuse and a reason for her to get away with killing her kids? No. Or conspiring to do that? No. But what I'm saying within the court case itself and why she was gone for that year, I think that's what happened. And each time she could have been terrified of the jail for some reason. You know what I mean? We don't know because we didn't get to see them documents. So we can't really question or attack on that, right? Okay. Okay, we don't know, Lisa. Thank you again, JDR, for your super sticker. I appreciate it. We don't know what the medical reports have said, so we can't say that. We can't say it. I can say one thing that I don't, and I'm not, like I said, I'm not a medical professional, but I don't think she could fool people for a year. These were doctors, like specialists. I don't think she could fool them for a year. I believe that there is something there that causes her some kind of anxiety or panic attacks, that when she's in that courtroom or knowing she has to go, that it causes her to flip out. I think that is very possible. And that would put her in a position where the lawyer can't even talk to her. Okay, Lori, what do you want to do? Get away, get away, get away. You know what I mean? If she's flipping out, he can't get what she wants. He has to do what she wants him to do. If he can't get a response from her because she's flipping out, then they can't move forward, right? But Lori's defense and Lori have never asked for this court case to go on any other day but that October 11th, which was within her speedy right, constitutional right. It's always been the government or the other side that keeps pushing it out. That's not Lori's fault. Sorry, you guys. And each time they do that, I've seen a pattern here. Each time they do that, she flips out. So that's why I'm thinking it is some kind of PTSD or ADHD or panic attacks or something. It's got to be something like that she flips out every time that there is a change. When she's supposed to have her speedy right, how come my rights are being violated to suit John Pryor all the time or the court. I want my trial. Let's go. You said I did this. I want you to prove it. And that's her right. Lisa, sadly, I mean, thank you and I appreciate your opinion and I have no problem with it, but I disagree. I think that this is exactly what's been happening. That she has some kind of disorder like that. I'm not saying that she did not know what she was doing when she conspired to do this with her kids. I think she knew everything. I didn't think I don't think she ever thought they'd get caught. So there's a big difference here, you guys. I'm not saying that she wasn't competent when she did those acts. I believe she was. But I'm saying throughout the court process, I think that's when the panic, maybe some ADHD or some PTSD, something triggered. Yeah, I mean, we don't know what's going on because we're not privy to the information. We can't read her medical reports. Like I said, I want to be clear. I think she was fully competent when she did what she did and what she involved herself in all aspects. I'm talking about since she's in jail. I think the constant changing in the dates and everything else, that's what's flipping her out. Okay, so the government cannot show good cause to bring Lori Vallow Daybell to trial over 3 years from her arrest and almost 1 year from her arraignment. Now, this would be different if she waived her right to a speedy trial. She didn't. So this court should find that the government has not met its burden to uphold their constitutional rights. This case should be dismissed. Okay, and here's the certificate of service. And I don't think the government saying, well, the overbearing reason is it has to be something to do with the trial itself, like evidence or this or that or a problem with witnesses or something. They cannot just say, well, we want to save money and have these together because we're going to be presenting the same evidence in both trials. That's not an excuse to take away somebody's rights. Put yourself in this position. If it was you and you had a right, you were arrested for something and your rights kept being violated, you'd be pretty pissed too. I don't think she will, Mary Michael. I don't think she will. Mary Michael says if she gets off, she may spiral every minute of every day, not trying to be mean. She needs to pay in some way for her misdeeds. She wants out so she can return to her formal gut. Yes, I believe that too. And like, I'm not knocking that she may be going through some kind of psychotic episodes while she's incarcerated, that they have to bring her to get evaluated or get treatment. I believe that's happening. I don't know, like, if I ever got arrested and thrown, well, I worked in the legal field for over 30 years and most of it in criminal law. But if I ever got thrown in jail, I don't know what the hell I would do. I would spiral. No, get me the hell out of here. Like, to have, I don't know. I think I would spiral, especially if okay, look at Willow. You're only here for a couple months. We're going to trial. We'll have you dealt with or out or whatever. Okay, I only got to put up with this for 3 months. You know what I mean? And then that 3 months is put off again and then again and then again. And I would be losing my shit. So I get it. But it doesn't take away from what she did, because I think she was fully competent when she did the acts that she did. But the prosecution is handing her a dismissal on a silver plate. I said that back in November when they said that before that, when they were going to take away her October date and put it to January. I said it back then. I said, this is going to end badly. This is going to be a mistrial. This is going to be a dismissal. This is going to be the biggest ground for appeal that I've ever seen. Now, they've not only changed her date from October 11th to January. Now it's from January to April. And now they want to put it out another year. I can see that flipping somebody out. Put yourself in that position. Not you didn't kill your kids and all that, but put yourself in a position where you're denied bail and you feel, or you're fighting that you didn't do this. You know what I mean? Even if you did, you're fighting that you didn't do this and you want your day in court. You want to prove it to get the hell out of jail and get back to your life. And the prosecution does this to you, or the other side does this to you. You know what I mean? And I'm not saying put yourself in a position where you've killed your kids, but something that you're held and your speedy trial rights are constantly taken away from you. You would be flipping out. I know I would. And like I said, by no means do I agree that she was incompetent when she did these acts. I think she was fully competent. She knew what she was doing. She is. See, there we go. Mom Osser says, I was put in for like 6 hours for improper lane change. I freaked out even in that amount of time. It's scary. Yeah. So can you imagine, Mom Osser, you're in there and they say, okay, look, you're going to go see the judge tomorrow and it'll all be dealt with tomorrow. Things are going to, be decided tomorrow. Okay, I can do it till tomorrow. And you calm yourself down and you get through it. But then when it's time for you to go and you're still sitting in your cell and they say, well, it's been vacated. You got to wait another month, another 2 months. And you start flipping out again. They got to get you higher medication to get you calmed down. You're finally calmed down. Okay, it's only now, another month. I'll get through it. And then it's changed again. You know what I mean? Like, you got to put yourself in that position. And like I said, I am in no means saying that I'm happy about it, but the prosecution did this. The prosecution handed her a dismissal on a silver plate. Hey, Crime Curious. Lisa, I'm going to say it again. She was ready to go for her January trial. She's ready to go. She didn't do anything to prolong that court date, that trial date. John Pryor did. This is not on her this time. And I hate having to defend her, but I have to be fair. I have to. This now is not on her. This is on the prosecution and John Pryor. And the judge. They're the ones that put it to this point, not Lori. When they changed her date from October to January, she did spiral and she went back into the mental institution. She was out in time and ready to go for the January date. It's not her that put it off. It was John Pryor. After John Pryor demanded that date, and the prosecution agreed to it, and so did the judge. So they put it off to April. Can you imagine her now? She's flipping out again. That's not her that did that. That's them. It's on them. And since her arraignment, where she was guaranteed a speedy trial, there's nothing that she has done that has stopped the trial dates from going forward that were given, including her October 11th one. It's all on the prosecution, John Pryor, and the judge. They decided that. Not her. She was ready to go. So I can't keep blaming what's happening now on Lori. And I said this back then. If they do this, if this judge agrees with the prosecution and John Pryor to move that January date, she's going to walk. I said it. Go back to that video back then. Go back and listen to it. I said, she's going to walk. She's going to walk. And what did they do? They went ahead with it. Then they vacated that date and set another date for April. Right then and there, I knew she's walking. And now they're even going to vacate the April date. Right? Put yourself in that position, not with killing kids, but having a date and wanting to get this over and done with. And the other side keeps violating your right and keeps moving it out and out and out by nothing done by yourself. Doesn't fall on her this time. I wish we could blame her, but we can't. Blame John Pryor, blame Rob Wood, and blame the judge. The state and the judge should have known better that they are violating her rights to a speedy trial. And I think they've taken for granted how lax Jim Archibald has been with, okay, she's got a right to a speedy trial in October. We'll wait till January. When you lax like that as an attorney, they're going to walk right over you, and that's what they're doing. All these decisions since then have been made by John Pryor, Rob Wood, and the judge. And James Archibald played it. They played right into his hands. Because in the back of his mind, he's saying, look at each one, he stands up and he says, look at, no, my client wants to go through January 9th. And he sits down. He's put that on record that she's demanding her speedy trial. That's all he has to do at this point. So then we're coming up to the April date, and there's a motion to continue again. All James Archibald has to do is stand up and say, Your Honor, my client has not waived her right to a speedy trial. She wants this trial. And he's sit down. And if that judge puts it out, each time he does it, you're giving a reason for him to do exactly what we just seen with the motion to dismiss. And they handed it to her. Handed it to them on a silver plate. That could very well be, Mary Michael. Yeah, that could very well be. Oh, we're going to have to wait and see, Lisa. And if the judge does force this to go forward, and if he does give it continuance again, and James Archibald had to file this before the trial date. So he's done that. So even if, say, the judge separates the trials, Chad, you're on your own now. We're going through it, Lori, on April 3rd. This is still going to be a number one reason to appeal. I don't know what's going to happen at this point, but I will not be surprised if it's dismissed with prejudice. Won't be surprised at all. And if it's not, and they force her to go through with the trial, this is going to be their reason for appeal. So let's wait and see what happens. When that happens, we can look back on this video and you can say, well, Willow, you called it again. That's going to be their number one appeal right there. Exactly. I agree, the real angel. And like, I want you guys to realize I'm not for Lori Vallow whatsoever. I hope she fries. I wish I could be there to see, and I don't like seeing death. But to see this woman get the lethal injection, I'd probably be there. Because there's nobody more deserving than her and Chad for killing your own child, your wife, your ex-husband. No. Yep, me too, JDR. Okay, so let's go through this one now. So now this is the one that was filed late last night, or late yesterday, 9:12 a.m. it says filed, but we didn't get it into the record until this morning. So, James Archibald, filing again. Oh, sorry, wrong one. This one, we just went through that. That was the dismissal. Okay, so the 25th at 2:44. John Pryor files this again. Notice on hearing of a motion to sever. He just had it back on the 19th. Tried to sever it then, absolutely not. So then he went for a continuance. That it has been taken under advisement. I checked the court record this morning. There's nothing there yet. So he's filed a notion on a notice of hearing on motion to sever. Notice is hereby given that on the 9th day of February 2023, this here is when the dismissal is going to be heard. Okay? Now, this is not Lori's filing, but I do know, because I've seen a filing, that she is going to be, her motion to dismiss is going to be heard on the 9th day of February 2023 at 9:30 in the morning. So, John Pryor files this, and his is at 9 a.m. before hers. So that on the 9th day of February 2023, at the hour of 9 a.m., or as soon after as counsel may be heard, John Pryor, attorney for the defendant named above named, will call up for a hearing for the defendant's motion to sever before the Honorable Judge Stephen Boyce, District Judge at the Fremont County Courthouse in St. Anthony, Idaho. So, I don't think Lori even wants the trial separate. If you want my honest opinion, I don't think she wants it severed. So, now, what has happened? Wait till you see this last one that I'm going to show you. Remember I said to you earlier, every time something doesn't go according to plan, Lori spirals. When they took away her October 11th speedy trial and set it for January 9th, she spiraled. Okay? So between October and November 15th, she was again back in the mental hospital because she spiraled. Why? Because they changed her trial date. Okay? This is my opinion. I feel, and I've gone back and started reading, I haven't got a chance to go through it all, but I'm seeing a pattern. Every time something is changed and something that she feels has been set in stone, like her trial date of October, that's vacated. Her right is taken away. She spirals. January 9th comes just before the trial is supposed to start. Guess what? It's vacated again. Lori Vallow spirals and goes back into treatment. You see what I mean? So then, I think she was only gone a couple days when she found out that that was going to be vacated and the trial didn't go through. So I believe it was just like a couple days. She was in treatment, or they had to take her to get meds. I don't know what happened, but I know that she had left the jail for a day or so. And now when they go back to court last week, she finds out that April 3rd is going to be vacated. Guess what happened? Lori has spiraled again. Okay, let me get to it. I forgot that I had this one here, the notice of hearing. This is Lori Daybell saying that, see here, 9:30 a.m. on February 9th. She wants the motion to dismiss for lack of speedy trial filed January 26th. Motion for individual voir dire filed January 26th. Motion to disclose penalty phase information filed January 26th. Motion for pre-selection instruction for the juries filed. So this is in case they don't dismiss. They want this all done. The lawyer is asking for February 9th at 9:30 a.m. Look at Chad. Chad files this at 9 a.m. for 9 a.m. A motion to sever. And he filed that on what? He filed this on the 25th and picked 9 a.m. Okay, so it's not him that did it. It's Archibald. So Archibald files this the next day and says he wants a hearing on the same day, February 9th, but at 9:30. And he wants the motion to dismiss for lack of a speedy trial. And if that doesn't happen, then he wants to proceed with these motions here. So what did I get this morning in my mail? Here's what I got. Lori I believe, has been taken out again to the mental hospital. This mail is to inform you the change of status in a court event following the defendant Lori Vallow in court case number. Okay, whenever there's a change in status, whoops, and we know this from prior, anytime there's a change in status, that means that she's been taken from the jail and brought to the institution. And we know that from the last times this has happened. Even though they didn't bring it up in court until much later, and I think I brought that up in one of the December lives that I did, where the record was showing that there was a change in status. And I said, oh, she's back at the institution. And everybody's going, no, it's not. No, it's not. No, it's not. Yes, it was. So I'm assuming that she has now spiraled again. And seriously, here we go. Hello, Chad Daybell. Thanks for joining. Oh my God, people, look it. We've got Chad Daybell. Look at this. We got Chad Daybell in the room. What do you guys think? What do you guys think? Wow. Hey, Chad, you on your portal? Chad, since we have you here, can you please tell me why those children were buried on your property? Come on, Chad. I won't tell anybody. Come on. Just between me and you. Come on. Why'd you bury those children on your property? Chad, why didn't you look at Lori? The last court, you haven't seen each other in how long? Chad, why didn't you look at Lori? Come on, Chad. Get the fuck out of here. Where's my mods? Mods, get rid of that dude. Thank you. Oh my God. Here. He says, to all the pretty ladies in this chat, I'm sensing we were all married in past lives. Ignore my wife, please. She is sick and will die soon. Kids, they have a mission on the other side. Like, this guy is, wow. And then he says that one, if you're reading this, you have been chosen by God to join. These are deleted, so you guys probably won't see them, but I got them here. If you're reading this, you have been chosen by God to join me into eternity. First, we need to steal money from the insurance company. Squid venom is undetectable. Like, this guy is crazy. Yeah, just time him out, you guys. No need to block him. Just time him out. Comes back and starts doing it again. Just time him out. No blocking unless I see it when you guys remove a message. So if I feel they need to be blocked, let me block them, please. Just time them out. Who just blocked that one? Who blocked Mom Osser? Please don't do that. Not blocked her, but removed her comment. Mom Osser says, Chad Daybell, may all your days be full of darkness and feelings of suffocation throughout the rest of your natural nasty life. I wish I could put that comment back up there. Mom Osser, but I can't. Somebody removed it. So if you want to post that again, Mom Osser, you can. Please don't do that, you guys. Yeah, Nana, he won't show up in your chat because the mods are removing his comments. But I agree with you, Mom Osser. No, he's not blocked. He's just been timed out, which is what I've told the mods to do. Just time him out. Yeah. The real angel girl says, I can see Lori in her cell bragging I'm getting out. Ha ha ha. Oh. Yeah. Leah H. That is something that I wanted to touch on because not JJ and Kaylee, it's Tylee. Okay, let me find this up here. Yeah, it's not Kaylee, it's Tylee. All this time, JJ and Tylee, not Kaylee, still wait to be laid to rest. Yes, they're still being held at the medical examiner's office or the morgue, one of the two. They've not released their bodies yet or remains to the family until this court case is over. That could very well happen, truth don't lie. Well, we don't know yet. I mean, the prosecution knew that this was a real possibility and they've gone ahead and done it. So it looks like a potato in chat. Yeah, you guys won't see it on screen. My mods are taking care of that, you guys. But yeah, I just had to call people like that. It's like, it's a fake account. So I'm sure that YouTube will get notified of the fake account. You have to use your real name when you sign up, and he's got Chad Daybell. So I'm sure YouTube will do something about it. We don't need to. We can just keep timing them out. Okay, K-Much. Yeah, just time them out. Don't block them. Mary Michael. Oh my God, Potato. I knew you looked familiar and couldn't figure it out, Mr. Potato Head. That game will never be the same, right? Right? Yeah, I was going to buy that for my granddaughter, and it's like when I didn't. I didn't. No, I don't. I think Chad is. If you want my honest opinion, I think Chad is the mastermind behind it all. I like to picture Chad with a lifelong battle with a rare prostate disease. Yeah, the remains have not been released yet. Thank you, thank you, thank you, K Mitch. Thank you. I love you. But yeah, unless I don't care, as long as they are not cursing and swearing, and as long as they change any curse words, I don't have a problem with people going off on them. God, don't know. Hey, Shivani, nice to see you, my girl. They're evidence, so they are held to the end of the trial. The bodies are evidence. It looks like Bart Simpson. Oh, God, you guys. that was in a past life, Mary Michael. Oh, God, you guys. Okay, so let me get this up. I think, hang on, let me just check before we get rid of this. Let me just check and make sure. What did I do? I don't know. Okay, there we go. Let's see if there's anything that has been filed in Letitia Stout. Oh. What's this? Letitia's back in court February 2nd. Hang on, you guys. I haven't seen this yet. So, I don't think I've seen this. Hang on. Let me just check. Yeah, let's pop onto this just for a second, you guys. It's nothing big. But I want to show you this because this is something that I brought up beforehand, and people have said they haven't been able to find it. So here it is stated. This is matters to discuss on February 2nd. Don't forget, she is supposed to have a pretrial conference on February 23rd. She is going to court on... I thought she was in... Hang on. March 20th, her trial starts. And then a pretrial readiness on March 9th. So I don't... Okay. So this is what I was talking about right here. This is just matters that they want to discuss on February 2nd. I don't know if I even went over this because it's really nothing major. But it says here, and this is what I was saying, okay? This here. Defendant previously entered a plea of not guilty by reason of insanity. The defendant has been examined at CMHIP. The court has received a report regarding that evaluation. The court understood that the examination was to have taken... Oh, that's not it. Oh, this isn't it. Hang on, you guys. This isn't it. I'm on the wrong document. Hang on. Let me find it. Where it said... Come on. I think it's in here. Hang on. Damn it. I don't know. I'm not going to waste you guys' time. But there was... there was a document there where her defense or the prosecution filed a document saying that when Letitia wanted this other evaluation done, it was not to change her plea from not guilty to not guilty by reason of insanity, that it was just an evaluation for what she did after the murder, blah, 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 and that they had no intention of changing her plea. And then when the evaluation came back, that they returned to court and changed her plea to not guilty by reason of insanity. So I had that document. I do have it, you guys. I will find it. And what I'll do is I'll post it on my community tab. Because a lot of people were saying, no, she pled not guilty by reason of insanity right from the beginning. No, she didn't. It was only when the defense attorney lied to the judge and said, look, judge, we only want to get this done so we can see what her mental health was after the fact, which would not be an insanity plea because the act was already done. And we have no intention of changing her plea to not guilty by reason of insanity if you allow us to do this evaluation. So the judge allowed it. And what they turn around and do? Exactly what they said they weren't going to do and what they weren't going to use it for. They turned around, they changed her plea to not guilty by reason of insanity. And they're using that evaluation that they had done to do it. Because every other expert has said that she was not insane when she committed these offenses. So That document is the most recent, January 12th. Thank you, I'm curious. Let me go and see. I know I have it. So it was January 12th. Oh, here. Not the January 12th. That's the attachment, so it must be this one. Must be in here. Hang on. Oh, here it is. Thank you. Crime Curious, you're a lifesaver. Round of applause for my Crime Curious girl. I have Crime Curious back up on panel because she's head deep into this case as well as some others that she is writing a book on. So if you haven't checked out Crime Curious, let me put a link to your channel. Hang on a sec here. Because I have the document now, so... Okay, I've got it here. Okay. Yes, we do. Okay, so here's the link to Crime Curious. If you guys want to go and check her out, give her a like, sub up to her. She's writing a book on several of the big cases that we have covered. Okay, so let me share this. Thank you, Crime Curious. I appreciate you. Present, share screen. Here it is here. Okay, so on November 4th, the defendant entered not guilty pleas to all counts, and counsel for the defendant gave oral notice of their intent to introduce mental condition evidence, specifically stating that she is not entering a not guilty by reason of insanity plea. The court ordered an in-custody evaluation to be completed at the Colorado Mental Health Institute in Pueblo. The case was set for jury trial on March 28, 2022. On February 11th, which was like months later, just before her trial was set to begin, the defendant changed her plea to not guilty by reason of insanity, and the counsel for the defendant stated on the record that they have good cause to change the plea as they have an expert that reviewed material. There appears to be some sort of bleh. Counsel did indicate that his expert has not done the insanity evaluation yet. The court ordered another evaluation at CMHIP and vacated the trial date of March 28, 2022. So on August 4th, the court received the report from the hospital finding the defendant legally sane at the time of this crime. On August 23rd, the defendant filed a motion for second insanity evaluation pursuant to CRS 168106, requesting that Dr. Dorothy Lewis conduct the examination. On August 25th, 2022, that's that crazy doctor I was telling you about, that she's really old, she's ready to retire. So on August 25th, the parties were in court to discuss the logistics of the second evaluation, and defense counsel informed the court on the record that an evaluation report is expected to be completed within 30 days, as their expert, Dr. Lewis, has been reviewing materials for a while. October 13th, defense counsel withdrew their request to have the EEG. That's what they were fighting for, you guys. So they withdrew the request to have an EEG. That's where she'd have to be hooked up to that monitor thing that's on her head for 72 hours. Done as part of their expert's evaluation, stated in chambers to the court and the prosecution team that they anticipate that their expert's evaluation will be completed by December 1st, 2022. The parties agreed to set the case for its current jury trial date to March 20th, 2023, which is a year after, almost to the day, because she was supposed to, the trial date was initially March 28, 2022. So now it's March 20th, 2023. So there we go. So that's what I wanted to show you, where she said that they weren't going to use that evaluation to enter an insanity plea, and then turned around and did exactly that. And now they got this other doctor that they feel, this doctor seems to be on the side of defendants and looks for any little thing that could possibly connect an injury or a mental health issue or something to the defendant to get them off. That's her main objective, is to get people off. So yeah, so there's that. And like I said, we don't get to see those evaluations. We're not privy to the mental health records, any medical records. We don't get to see. Shivani says, if Letitia had been insane, she wouldn't have tried so hard to conceal her crime, which shows she knew. Yeah. But now they're saying that there could have been, don't forget, you guys, she says, oh, well, I fell out of my bunk and I smashed my head and blah, 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 and all this. I think that she thought that that would never come out, but she brought it out herself. And that by this doctor finding maybe a small bleed or something in the brain, that they could have said, look, that's what made her do what she did. But no, there's no indication that there was an injury then. It's only after the fact that she got that injury. So I think they kind of got blown out of the water on that. Yeah, another entitled one. The Real Angel says, another entitled one. Absolutely. Yeah, she'd not be getting the EEG. But they fought for that. They were fighting for that for the long. Oh, we need this EEG. We need it. We need it. And can we pick the hospital? What? So she can escape? Are you crazy? You need an EEG. But no. And I don't think I think the reason why they got rid of that and decided they didn't want it, because they fought hard to try and get that. That was a 72-hour test that would have had to be done. And Pueblo wouldn't do it because they wanted an outside doctor to bring in all her team and all their equipment to do it at their hospital, which is not only a security risk, but insurance purposes too. If one of them get hurt or something in that hospital while they're doing their own evaluation, and it's not one of their doctors that should be doing there, they don't have rights to that hospital, whatever, it opens up a big liability suit, right? So since they couldn't have it there and the jail said they weren't equipped to have it done there, they wanted to select their own place to get it done. And that was a big no-no too, because that presented a huge security risk. Like how far is this doctor willing to go to get her off? Like, yeah, let's put her in a less secure place and have her escape, as she has already tried to do. So that was a big no-no. And I think that they realized that they were not going to get what they wanted. So they just said, well, forget it. We don't need it. We're just going to do an evaluation on her. I don't know. It just seems all funny to me. And I don't mean funny in a way, ha, ha, ha. I mean, there's some sneaky stuff. Funny, sneaky stuff. And it didn't work. That's what I found funny. That this doctor actually, and Letitia maybe actually thought that this was her last and final attempt to be able to maybe escape. I don't know. Just saying. I don't know. But that is set to go March 20th. Trezell and Jacqueline West are also supposed to be in court. Their trial is supposed to start January 30th. Now, I don't know if that's still going through on January 30th, but it's supposed to. Lori has a pretrial conference on February 23rd that runs to the 27th. Letitia's supposed to be back in court for a motions hearing on February 2nd. On 31st, Lori also has a review hearing at 9:30 in the morning. And then February 9th, both Chad and Lori are going to be back in court again, same court. Chad to sever And if not sever, if he doesn't get the sever, then he has a whole list of other motions that he wants to present. And Lori is going to be there on the motion to dismiss her case. Chad's is to be heard at 9 a.m. and Lori's is to be heard at 9:30 a.m. So that's going to be interesting, you guys. That's coming up next week, I think. The week after. In the next little while, anyway. Okay. Did Pryor get the evaluation done on her that he wanted? Pryor cannot request an evaluation for Lori. I don't remember John Pryor ever asking for an evaluation to be done. Are you talking? Well, you said John Pryor did Pryor. Pryor is Chad Daybell's defense attorney. And John Pryor would not be able to request evaluations on Lori, if that's what you're asking. I agree. I think it's a little too late, but the judge did state in the January 19th hearing that if things weren't all ready to go, if the defense, John Pryor, the day before the trial is to start, if he felt that it couldn't go, that he wasn't ready, that the judge would make a decision at that time. And I think he was speaking on whether to sever. But what does that mean? Does that mean that Lori is again pushed out? I don't know. I think that the judge is really going to push for Lori at least to go through in April, but I think it's a little too late. I think Jim Archibald filing that dismissal for all her charges is actionable, and Mamasser, no, he can't request any testing on Lori. Man, I'm getting Lori another attorney confused with Pryor. Oh, Mark Means. Mark Means was thrown off the case by the judge, not competent to. There was a conflict of interest because he had represented both Chad and Lori at one time, and then the judge said that he wasn't competent to fight this case, the seriousness of this case that Lori had. So that's when Jim Archibald came in. Yeah, John Pryor cannot request any kind of mental health evaluation on Lori. Oh, that's not done yet, Mom Osser. They are going to still go at it because John Pryor wants this Chad Daybell's trial put off now until 2024. And Rob Wood wants this to all go through now on April. Oh my God, I'm losing my dates here. April 3rd, because Rob Wood now knows that they could lose Lori for violations of her rights to a speedy trial. So he did apply to have a continuance on January 19th. In that was one of his motions to continue the trial. Let me just check the file while we are here. I still do not see anywhere, unless it's just filed now, that the judge gave any orders on that yet. Let me just check. Oh, objection to motion to continue the order. Let me see what this order is. there's that order and there's this order. I think those are the Lori ones that we just went over. Okay, here we go. How did I miss this? Okay. So, I think this is a little too late, you guys, but here it is. There is an order. The defendant's motion to continue. On January 3rd, the defendant filed a motion to continue the trial. On January 12, 2023, the state filed an objection to the defendant's request to continue the trial from April 3rd, 2023 until no sooner than April of 2024. The court called the motion for a hearing on January 19th. For the reasons stated on the record, the motion to continue is denied. Okay, so they have to go. Now, and this hasn't been, this has not been dated. That irritates me. Because this has already been filed with the court and there's no date here. That irritates me to no end. But anyway, so he denied the motion to continue. But he also stated on that court date that if John Pryor felt, like a couple days before the trials to begin on March 20th, or on April 3rd, sorry, that if John Pryor felt he couldn't go through, then they would have to discuss that at that time as to sever. So he has already filed a motion now to sever anyway. Lori's filed a motion to dismiss. John Pryor had previously filed a motion to dismiss his case. That didn't fly. It was denied. So it's going to be interesting, you guys, as to what is going to happen on February. Let me just see here. February 9th. I'm going to put this on my calendar here. February 9th. I thought I wrote it down, but I did. It's going to be interesting to find out what happens on February 9th because they are both going to be back in court. Chad's lawyers have filed motions to sever as well as other motions. And Lori has filed a motion to dismiss her case because of violations of her constitutional rights of a speedy trial. So from the looks of this, it was denied. But that's what I was saying. I think I forgot to finish. But the judge had said to John Pryor that if he wasn't ready to go, say like on the Monday, the 6th, or whatever. No. April 3rd, right? April. Lori and Chad's trial starts on the 3rd. So say by the 31st of February, or March, sorry, 31st of March, if he feels that he cannot proceed with trial, that he's not ready, then the judge is going to make a decision at that time as to whether he's going to move the trial further down the line for the both of them, or if he's going to sever. That's what I think is going to happen. I do believe that he's going to sever if it gets to there. If Lori's motion to dismiss is denied, to me, that sets her up for an appeal of any conviction that she may get. But if he does feel that he's going to continue and deny her motion to dismiss, her trial is going to go through on April 3rd. He's going to have no choice. So I do believe that Pryor at the end of March is going to say, I'm not ready and I can't be ready. So the judge is going to have no choice at that point to sever. John Pryor's already filed a motion again to sever, which will be heard on February 9th. The judge was smart. He would just sever it right there. Because it's going to end up happening anyway, one way or the other. But I mean, there's so much going on all at once. Because Lori has filed for dismissal of her charges because the government took away her right to a speedy trial. And I don't know. I really don't know what Voice is going to do. I really don't. But as far as I'm concerned, she should get it. And I don't like to say that at all because I want her to fry. But the law is the law. So they have violated her rights excessively. They're supposed to have her to trial within 6 months of being arraigned, which would have brought us to October of 2022. They put it off to January. They put it off to April. Now they want to put it off again. No, there's got to be a line somewhere. Boyce never had control of that courtroom as far as I'm concerned. So I don't know what you guys think. Let me know in the comments of the video. Once this is uploaded, this will probably go private for about 15 minutes, you guys, but it will be available once everything is uploaded to YouTube. So, okay, so I'm going to let you guys go. That's what we've got so far. If anything else pops up, I will be sure to let you guys know. Keep an eye on my community tab. There's a lot there. Also, my older reads you will find under the video tab. Everything new from the last 8 months and going forward, you're going to find everything under the live tab. Okay, because I use the streaming software now instead of having to upload. So if you upload, it goes into the videos tab. Streaming everything goes into the live tab. So you will find everything from 8 months ago and going forward. I'm going to continue to do it this way. You will find all the new stuff in the live tab. Okay, so until the next time, thank you to my mods for being here. I appreciate you. You guys take care of yourselves. Stay safe. Love you guys to the moon and back. Bye-bye for now.